Joining me now, Ashraf Essop, immigration lawyer, to help us understand what that case will be about tomorrow. Ashraf, good to have you, and thank you for coming on this afternoon. This portion of regulation that this particular matter is dealing with, tell us a little bit more about it. I believe Section 8 of the Immigration Act is what we are dealing with, where it's a process, I suppose, of appealing a decision that adversely affects an individual's rights.
Good afternoon. Thanks for the opportunity. Yes, that's correct. What we discern from the statement handed down by the Department of Home Affairs is the following. A decision to declare the applicant a prohibited person was made. Now, that is normally in terms of Section 29 of the Immigration Act for whatever reason. But 29.2 says that you may approach the Director General for good cause not to be declared a prohibited person. It appears from what I'm reading that this was indeed the case, and then it went up to the minister. So it appears that the DG had refused good cause not to be declared prohibited, and then you have a right of appeal if a decision is coming from the DG in terms of Section 8.6 to appeal to the minister. And now the minister apparently has come back and said, no, I actually think the DG is correct in not giving you good cause. Yeah. So again, judging from what we've read, it appears that the matter then proceeded to court. Now, no doubt, if you are aggrieved by a decision of any public official made in the course and scope of his duties, then relief lies to the High Court in terms of a piece of legislation known as the Promotion of Administrative Justice Act, or PAJA. And under PAJA, you may point out to the judge that, look, I think I have been unfairly dealt with procedurally and substantively. And substantively holds a number of grounds, such as the decision has to be without bias, and it has to be reasonable, etc. We don't know on what basis the matter went to court, not yet anyway. But again, judging from the statement made by the Home Affairs, it appears that the judge said, look, I'm not in a position to make a ruling on this because I'll be infringing on the separation of powers. I'm handing it back to the minister. My understanding is that process is now complete and the minister has made a final judgment. And therefore, according to Home Affairs, when the final judgment has been made, then the applicant no longer enjoys any status in the Republic. He's exhausted his legal remedies. He's now declared illegal, and illegal people have to be deported. The deportation procedure can be preceded by an arrest, detention, and then deportation. In many ways, we're actually in the dark about what really happened, and I think we'll only have an opportunity when the matter is aired in court tomorrow. It may be called tomorrow, it may be called on Tuesday. It depends on the prosecution. But basically, that's what I understand from what I've been reading. However, there was an important statement made by the General of the SAPS, and he said that he didn't specifically mention this, but he said, look, I'm coming after all the pastors that have got fraudulent documents. There was some kind of indication that the work permit might have been fraudulently acquired. But that's as far as we know of what has transpired.
And Ashraf, is there a point in this process now to take this particular declaration, however be it upheld by the minister, still on review, because a church denomination is asserting that, well, this decision was politically motivated, and so they are calling it bias?
Well, if the decision is biased, then you have to find something in PAJA that assists you. So a decision made arbitrarily or capriciously or with bias has to be proven. Now, your question is the minister's decision going back to review? I would suggest, depending on what the minister stated, we are not privy to the reasons given. One of the fundamentals of law is that you have to give reasons, and the reasons have to be reasonable, they have to be understandable, in the sense that the person receiving the reason says, okay, now I understand what you mean for, or the reasons you're given. I now understand your reasoning behind that. But in the absence of proper reasons, that could be one of the bases that you actually approach the court, or using PAJA, Section 5, request reasons in writing for the decision already made.
Yeah.
So it will be interesting to see on what basis, if any, a further appeal is made to the High Court based on the minister's latest decision.
Ashraf, appreciate your time. Thanks for joining us. Immigration lawyer there, Ashraf Essop, helping us understand, of course, the details, the intricate details of what is going to be challenged in a court tomorrow.